All right, let's go ahead and begin. Once again, my name is Tim Parks. Thank you for joining me this afternoon or wherever you are watching this, whenever you are watching this on our social series for this month. Today I'll be speaking on relationships and planning, and specific to estate planning. Relationships, of course, are a huge part of our estate plans and how they affect our estate plans. And so we're going to discuss some of that. We'll take a look at the agenda here. So the agenda that we have today, first of all, we will start off with some general statistics and demographic information on marriage nationwide as well as specific to Colorado. Then we'll take a look at some types of relationships and different agreements. One very prominent one that comes up is common law marriage and what that looks like. We'll talk about civil union, domestic partnerships, living together agreements, and things like that. Then we will apply that to estate planning, and we'll look at the ramifications of marriage and relationships in our planning, specific to the elective share, beneficiary designations, and how those can control who is receiving something from our plan. What does it look like in blended families, and what do we mean when we say blended families? We'll talk about some planning strategies for marriage and for relationships as they come up. And then we'll have a conclusion. At the end of this presentation, if you're watching live, we will have a chance for questions and answers. And if you look at your screen in the middle, there should be a place where it says question and answers. If you have a question while we're going along, please feel free to go ahead and submit that on something. However, I'm going to try to make sure that we address the questions at the end. And so we'll sort of take a look at those questions. But I don't want you to forget your question if we pass a slide that's relevant to you. So you can go ahead and submit that. If you're watching this later from our website and you have a question, we encourage you to give us a call. Our number is on the left-hand corner of the screen there, 303-670-9855. We'd love to hear from you regarding those questions. All right, so let's go ahead and jump into some estate planning items. This screen represents our definition of estate planning. We always start here as a foundation for what we're trying to accomplish when we talk about estate planning. And it says, I want to control my property while I'm alive, take care of me and my loved ones if I become disabled, and give what I have to whom I want, the way I want, and when I want. Furthermore, if I can, I'd like to save every last tax dollar, professional fee, and court cost legally possible. This is our goal. And oftentimes people enjoy the last sentence of that the most, but this is what we're trying to accomplish for each of our clients. Okay, so jumping into some general demographic information. In 2017, half of Americans 18 years of age and older were married. That seems like a pretty high number. The number one reason for getting married was love. Love was the number one reason. Commitment and companionship were follow-up reasons, especially in elderly couples. Cohabitation is also on the rise. We see this often with clients as they come in with a significant other, and all they are doing is cohabiting. Remarriage is also on the rise. Remarriage is after the first marriage. 4 in 10 new marriages involve a remarriage. And a growing number of marriages involve different views on religion, but not different views on politics. I thought that was somewhat interesting. In Colorado, the statistics are not too far off the national averages. In 2018, the marriage rate was 7.6 out of 1,000 people. And this is just to give you a little bit of a context for where marriage fits. In the same year, the divorce rate was almost double that, 13.52 out of 1,000 people, according to the American Community Survey. The overall cost of a wedding in Colorado, and if you are a parent, maybe you've felt this, is $25,000. It seems pretty high. My wife and I got married, we did not spend $25,000. I don't think we spent that much even with our honeymoon included. And then the top cities in Colorado to tie the knot include Denver, Colorado Springs, and Boulder. Now we are seeing a little bit of a shift from the paradigm around marriage. In 1950, married households were about 80%. Today, that's closer to around 50%. Cohabitation has doubled prior to marriage, and the paradigm used to be that you would date or court, and then you would get engaged, and then you would get married, and then move in together and then have kids. Now what we're seeing, excuse me, more often is people who date or court and then they move in together and then perhaps buy a home and then get married and then have kids. And so that's changed a little bit. In 1960, 59% of 18 to 29-year-olds were married. Today, that number is about 1/3 of that, or 18%. Blended families are also more common. And what we mean, I'll use the term blended families throughout the presentation, what we mean by that is families in a second marriage that have children from a prior marriage. So you may have a husband and they have a couple of kids and they've gotten remarried and now they have children with their new spouse. That would be a blended family. Or both spouses may have kids from a prior marriage that they're bringing into the family. But it's any time you have stepchildren or stepmom or stepdad, that would be considered a blended family. It's also more common for two people to have children together and not be married as a part of that cohabitation. So again, relationships is a huge part of what we see in estate planning. It comes up all the time. I was just thinking about this question, and you can ask yourself this. Do you personally know someone who's had a relationship change in the past year even? And I do. My youngest sister recently got married, and that's a relationship change. And then the other question that I have for you to think about is, do you know people, yourself included, who would list their spouse or their significant other as a primary role in their estate planning? And we're going to talk about how sometimes that happens by default. So this is some demographics on relationships. Let's take a look at this specific going through the marriage process in Colorado. You do not have to be a state resident, but you do apply in person at the county clerk's office. You have to present a valid ID, you have to be older than 18 years, and you have to return the marriage certificate signed and witnessed within 63 days of the wedding to the clerk. People who can conduct a marriage ceremony include judges, magistrate, public officials, clergy, or ordained family members or friends. So this is sort of the traditional marriage process, and when I say traditional marriage, I don't mean the traditional marriage versus same-sex marriage. I mean the traditional marriage process. All right, so that's going through getting married. Here's a list of types of relationship unions that we will analyze a little bit. The first one is the traditional marriage ceremony. That seems pretty clear. Then there's civil unions, and then common law marriages. Other agreements that sometimes come up include cohabitation or living together agreements, domestic partnerships, and then something that would apply to married couples would be a premarital or a postmarital or antenuptial agreement. Let's take a look at some of these in detail. We've already talked about the traditional marriage process. So the first point there says refer to the process above for the traditional marriage. No surprises there. I don't think there was anything that would be confusing about that. Then we get to civil unions. These first became effective in 2013 in Colorado, and the requirements were that two eligible persons, they cannot be married to another. They have to be over 18 years of age, and they cannot be related. They would fill out an application, and within 35 days, they would get the civil union certified by the clerk and recorder. Why people would do this is so that these two eligible persons could receive the same benefits of a married couple that they would have under a divorce proceeding or an inheritance proceeding, or even if they own joint property. So things like that, but they do not get the same tax benefits because the federal tax code does not recognize a civil union as a married couple. This was very prominent back before same-sex marriage was recognized nationwide. And so this was a common way for same-sex couples to have some of the same benefits as a traditionally married couple, but they would be in a civil union to each other. We don't see this very much at all. It's not nearly as common now that same-sex marriage is recognized. And so this is a very unique form of a relationship that we don't see as much of. The next one is common law marriage. And I've tried to itemize or list some states that include common law marriage. And right away, you'll notice that some states have like an asterisk next to their state. So for example, down the list, if you look at New Hampshire, That allows common law marriage, but it's for inheritance purposes only. However, going back up to the top of the list, very second on the list is the state of Colorado. Colorado allows common law marriage. And we'll take a look at the requirements of that in just a second. Other states like Oklahoma, they have some requirements that you have to conform to. And then what I'd have you pay attention to is the number of states on here that do not recognize common law marriage. We'll talk about how that affects inheritance and estate planning in just a second. But right off the bat, the principle that you should know about is if you are validly married under the common law marriage in one state, like Colorado, and you move to a state that doesn't necessarily recognize common law marriage, like Arizona, that state still has to give full faith and credit to your valid marriage, but there may be some issues in trying to prove that, as we'll see. So what are the requirements for common law marriage? Well, I asked the question here, are you accidentally married? And the answer is probably not. I mean, that's sort of a humorous question, but probably not. You're probably not married. But consider what these requirements are. And these are found in Colorado Revised Statutes 14.2-109.5. The requirements are, number one, that you agree to be married. Number two, that you live together. And number three, that you hold yourself out as being married. If those three requirements are met, then you meet the definition of common law marriage. Let's analyze them in turn. First of all, you agree to be married. How would you go about proving that you agreed to be married? Well, if both individuals, or both spouses, are able to testify that they agreed to be married, then that would obviously be met. But what if one spouse is already deceased? And this is where this comes up. One spouse is deceased and the other spouse would like some of the marital benefits that come with being married. And so they hold themselves out as common law marriage and they make a common law marriage claim. Well, in that claim, they have to prove that they were married. And so what they have to prove is that they agreed to be married. In that situation, how would someone go about proving that they agreed to be married? Well, they could always testify that they had agreed to be married. Perhaps there would be an anniversary card that would show, hey, at some point in time, we agreed to finally get married. And so this is what our anniversary card is representing. Perhaps they list themselves as an emergency contact or something like that, but they'd have to get somehow they'd have to get some form of evidence to prove that they agreed to be married. That's the first one. The second one says that they live together. Now, a common misconception about this is that you have to live together for a certain period of time. Notice that's not on the screen. There is no time required. You could live together for 1 day, for 2 weeks, for 6 years, whatever it may be. As long as you both live together, that requirement is met. And I had someone once say to me, I'm pretty sure my son is common law married. They've been living together forever, and so I'm pretty sure that they are common law married. Well, the amount of time that they've been living together isn't a huge factor. It's not on there at all. It's just that they do have to live together, and they have to meet those other requirements. The last one is that you hold yourself out as being married. And I make a note right off the bat that living together is probably not enough to prove that. And then the last point on this slide is that the burden of proof is pretty high because the courts don't want people to be surprised by their relationship. So how do you hold yourself out as being married? Well, here's some evidence that might show this. First of all, what if you refer to each other as spouses? Now notice that's different from referring to each other as fiancé. I had someone come in once, their fiancé had died, and she told me that they were common law married. And I said, okay, well, let's go through the requirements. Did you agree to be married? She said, oh yeah, he got me an engagement ring. And I said, well, actually that's evidence that you were engaged to be married, but not that you had agreed to be married. And so I don't think that that would speak to you meeting the definition of common law marriage because you hadn't agreed to be married. You had agreed to get married. You were engaged. So if you refer to each other as fiancé, that's not the same as referring to each other as spouses. But perhaps you refer to each other as spouses and you can have someone who will sign an affidavit swearing that they heard you say that. You might also have joint accounts, joint finances, joint ownership of property. Sometimes deeds will say John and James Smith as husband and wife. That's evidence that you held yourself out or pretended to be married. You might also use the same last name or have joint tax returns, or you might simply sign an affidavit affirming that you agreed to be married. One that's not on here is perhaps it's in your will, that you said in your will, I am married and this is my spouse. Well, that's evidence that you thought you were common law married, and that would be a part of holding yourself out as being married. So this is the evidence for common law marriage. I'll go back just a second. Look at these requirements once again. You agree to be married, you live together, and you hold yourself out as being married. Those three requirements are met, you are common law married. Now, notice that there is no such thing as common law divorce. What we mean by that is if you decide to start dating someone, you move in together, you agree to be married, and you start pretending that you're spouse, you may meet the definition of common law marriage. But let's say that relationship takes a turn for the worse and you decide that you want to move out and end the relationship. Legally, that's not a possibility. You have to go through a formal divorce proceeding or a legal separation proceeding. And if you do not do so, then you are still married legally to that person. And that creates a problem, especially if you meet someone new or if you want to get remarried. So you have to sever that marriage in a formal proceeding if you are common law married. Again, we mentioned this a little bit. Not all states have common law marriage, but they are required to recognize it through full faith and credit. That's the Sixth Amendment of the Constitution, I believe. And that may create serious legal issues if you're trying to prove in one state that you met the requirements for common law marriage in the other state that you moved from. So that's where this becomes a little bit difficult of an issue of proving it. If you can prove it, then they have to give full faith and credit. If you can't prove it, that may be an issue. So this is a common law marriage. This is a relationship that people can become part of. If you're not certain on where you and your significant other stand, or maybe you have a child or a grandchild and you're not sure about it, it may be an important conversation that's worth having. What about cohabitation agreements? Sometimes people who live together, especially older, will sign a cohabitation agreement. This is also called a non-marital agreement or a living together contract. And it protects their rights as a couple. It can function similar to a prenuptial agreement, but it does not indicate that you are married. In fact, it does the opposite. It's showing that you are not married because you're signing a non-marital agreement. So this is evidence that you're not married to someone, but you still want to have in writing how property should be distributed during the relationship and upon separation. And it may also include planning for disability, such as a power of attorney or planning for death. This is a cohabitation agreement. Interestingly enough, there's a case, there's no cases on this yet in Colorado that I'm aware of, but there is a case out in California, Marvin v. Marvin, that found regarding a cohabitation agreement that this is a type of contract that could be oral or in writing. Now consider proving an oral contract, and that always is a difficult thing to do. The court went on further to find that it could be an implied contract. You know, if the couple bought the TV together, then they probably intended to split the TV, or split the proceeds of the TV upon separation. The court went even as far to say that the court itself may presume that the couple intended to deal fairly with each other. And that's pretty broad discretion that the court now has to interpret what they feel is fair in this relationship. So instead of trusting that a court is going to get it correct or that everything is going to work out correctly if something were to happen, this is a way for two significant people who find each other are cohabiting together to spell out the way these issues should be determined ahead of time. So this is called a cohabitation agreement. What about a domestic partnership? This is really a similar relationship to a civil union, which we discussed a little bit earlier. Again, this was more popular for before same-sex marriages were recognized. This was a way that you would sometimes see same-sex couples enter into a domestic partnership. And it's basically two people who sign an affidavit that they're in a relationship of mutual support and they intend to remain in that relationship. They're each other's sole domestic partner. They are older than 18 years and they're both competent to sign. They share a life and home and they're not married or related. If they meet that definition and they meet those specifications, they sign this affidavit and they enter into a domestic partnership. Now, there are less rights in a domestic partnership that you would have in a civil union. A civil union is a little bit more formal. However, A domestic partnership does include the right to receive a partner's pension, a right to receive a partner's health insurance coverage, to file joint tax returns, but you do not get the federal tax benefits, a right to pursue a wrongful death claim, or a right to privileged communication if one of you is called to testify against the other. This is a domestic partnership. Again, don't see this very often anymore now that same-sex marriages are recognized. What about a premarital and an antenuptial agreement? These, of course, are useful for setting the expectations of property rights during the marriage and, if necessary, upon dissolution. There are some things that are required to make sure that this is an enforceable agreement. First of all, full and fair disclosure of the assets. If one spouse is concealing assets in any way, that speaks to the enforceability of this agreement. The whole agreement can be thrown out. Additionally, both spouses should have their own attorney look at this agreement. If one attorney represents both spouses and it happens to be the husband's attorney or the wife's attorney, then it could be unenforceable because it might look like the attorney is then biased towards their prior client of the husband or spouse or wife. And then the third thing to be careful about is executing this agreement too close to the wedding. The classic scenario would be that the husband goes to the wife or vice versa and says, I want you to sign this or I'm not marrying you tomorrow because this is the night before the wedding. In that situation, it sort of looks like duress or coercion because the spouse thought they had no other choice but to sign this, or they would be in a very embarrassing situation by canceling the wedding. And so that's too close to the wedding. It's not going to be held up in court. It's not going to be enforceable. Some things that you're not allowed to put in a premarital, or I should say it's not enforceable if you do put it into a premarital agreement or an antenuptial agreement, is child support or custody. You cannot determine that ahead of time. That's determined by a court and whatever is considered the best interest of the child. And then this is an agreement due to the statute of frauds that does have to be in writing. Okay. What I tried to do is I tried to sort of itemize the list of the relationships that we've looked at in kind of the different rights that they involve. Traditional marriage, common law marriage. The only reason I put common law marriage below the traditional marriage process is because not all states recognize it. And so you might have a little bit of an issue trying to go through that and prove that in a state that does not recognize it. Civil unions come right below common law marriage. Domestic partnerships come below civil unions, and then cohabitation agreements are below domestic partnerships. This is sort of a hierarchy of the significance of the relationship that someone is into. Okay, so how does marriage or how do relationships affect our estate planning? And this is what we really want to talk about. The first thing is the elective share and the problem with what we call I love you wills. Under Colorado Revised Statute 1511-202, you are not allowed to disinherit a spouse. So this is the elective share in Colorado, and it stands for the principle that absent a prenuptial or a postnuptial agreement, you're not able to disinherit your spouse. The formula there, subject to some limitations, is that your spouse is entitled to 5% of your assets for each year of marriage, up to 10 years or 50%. So think about that for just a second. If you were married to someone or if someone's married to you for at least 10 years, regardless of what your will or trust says, that person is entitled to 50% of your estate. Let me give you an example. I've been married to my wife 7 years in August coming up. And if I were to write a will that said, I want all of my assets to go to my brother or my parents, my wife could still make a claim for 35% of my estate because of the elective share. She's been married to me for 7 years, 5% each year, that's 35%. Let's take a look at how this applies in the example. Husband or H1 dies and leaves 100% of his inheritance to his wife. Now we would call that an I love you will. Refer back to the first point, the problem with an I love you will. So H1 dies and leaves 100% to wife in an I love you will. He writes it that way because he's saying to himself, I love my wife so much, I'm just going to leave everything to her, no strings attached, it all goes to her. Then the wife remarries and is married for 6 years to H2. Now, because of the elective share, on the wife's death, H2 gets 30% of the wife's estate. 5 times 6 is 30%. That is regardless of what H1 would have wanted to have happen, because it's possible that H1 and W have children. Now, finishing up with the last sentence there, H1 and W's children may receive the rest, and again, this is regardless of what H1 wanted. So that creates a little bit of a problem on the remarriage aspect of that, and it is very common for us to have couples come in who are remarried or have a blended family. And so that's the problem with an I love you will. If you write everything to your wife or to your husband in an I love you will, it's possible that you might be disinheriting your children if your spouse gets remarried because of the elective share. Okay. What about intestate succession? If you die without a will or a trust, then it is said that you died intestate. Colorado courts come along, and what they're trying to do is they're trying to determine what you most likely would want to have happened to your property. And they've created a formula under Colorado 15-11-102, Colorado Revised Intestacy Statutes. That formula looks at what your family information is, and it assigns your property to whoever fits the class of beneficiaries that is recognized. If you are married, your spouse is usually at the front of the line for a portion of your estate. Now, where this really comes up is when people are common law married. One spouse dies and they intend their inheritance to go somewhere else, but they don't realize that because they're common law married, their spouse is entitled to a large portion under intestacy statutes. It does take into account children and blended families. Again, it's very formulaic. It says, what's your family information? And based on that, who gets what? So intestacy succession. The other thing, and it's not on the slide here, is the order of priority for personal representative or executor. If you die without a will or a trust, then an executor or a personal representative has to be appointed by the court. Usually your spouse is first on the list of priority, whether or not they want to do that, whether or not they would be a good fit for that or not. Because they're married to you, they come first in the order of priority. Okay, what about beneficiary designations? A lot of times people will use beneficiary designations to pass assets along to their loved ones under contract law and outside of the probate process. That's fine. That's a perfectly valid estate planning tool. And so what will happen is you set up a beneficiary designation, let's say with a retirement plan or a life insurance policy. That company is going to push you to fill out a beneficiary designation. Well, if you're in a relationship, even if you're not married, you may be tempted, or you may put your significant other or your spouse down as your first choice, primary beneficiary. That makes sense. However, if you get remarried or if you get divorced and you leave that name on there, the issue is, does the company then have notice of that remarriage, or have you changed your beneficiary designation? If you get remarried or if you get divorced and you don't change it, the company is allowed to rely on the beneficiary designation when they're making distributions. They don't have to wait to see if you ended up getting divorced or not. And so that may be an argument, but it may not be effective because they may have already made the payout under the beneficiary designation that you had in place prior. ERISA, that's the employment benefits. That may also prevent you from designating a beneficiary who is not your spouse. We had this issue come up. A husband was trying to leave an inheritance for his daughter and for his son. So he listed his son as a beneficiary of a life insurance policy, and he listed his daughter as a beneficiary of a retirement plan that he had through his work. However, on his death, his spouse came along and they made a common law marriage claim and said that they were common law married, and they were able to prove it. And when they proved it, they then, under this Employee Benefit Act, were able to take the retirement plan away from the daughter. So the daughter was effectively disinherited because of the common law marriage. That's getting a little bit into the weeds as to what we go through, but I just want to give you an example of all the different ways this can be an issue. And then obviously the last point there speaks for itself. Failure to update beneficiary designations may cause significant issue for your loved ones upon your death. The last thing that we talk about before we get into some misconceptions is blended families. We've defined what those are. If both spouses have children from a prior marriage, they will likely want to plan around their blended family accordingly. And the goal might be challenging in that the goal is to leave an inheritance for the second spouse, and then also make sure that biological children receive their portion from the estate. Because if you leave it all to your second spouse and then that spouse turns around and gives it to their children, you might be disinheriting your children. And of course, that's going to create conflict between your second spouse and your children. It also creates a challenge when you are identifying who should serve in your plan. We call those helpers. When you're picking your helpers, that may create a bit of an issue for you as well. So this is the challenge of blended families. We see a lot of this. It's not uncommon at all. What are some misconceptions that come up when we are doing relationship planning or marital planning? The first one is love conquers all. And we don't see it necessarily in that format, but people will come in and they'll say, oh, I trust my spouse to do what's right. I'm going to leave everything to my spouse because I know that they're going to provide for my children. Or I know that no one's going to challenge this because we all love each other and we all get along. Hopefully that's the case, but we as attorneys realize that that's not often the case. This mindset is a key ingredient for potential disputes that cost time and money because the expectations may not be the same. It's not uncommon at all for someone to pass away and a spouse to receive the full inheritance from that death, and a child to say, I thought that my parent was going to leave everything to me. I thought that they had set this up differently. Well, that's the recipe that causes litigation. And unfortunately, relationships change. We know that as well. So what we recommend instead, second main bullet point there says, clear communication conquers all. And the goal here is to clearly spell out what the expectations are during and upon the end of a relationship, including death and disability. You can do that through some of the other documents that we've already addressed. Another one that we see, and this is a big one, is I just want to keep things simple. I'll have people tell me, oh, this trust that you're talking about sounds complicated. Or you're wanting to do what again? I don't understand this. I just want it to be simple. Let's just give it all to my spouse outright, or let's just give it all to my children outright. Well, obviously, we'd like for things to be simple. They're easier to understand when they're simple. However, we know that striving for simplicity may only increase ambiguity. And ambiguity is a recipe for litigation. If it's not clear what the intentions were, that's when people may say, well, I'm going to go to court to challenge this because this is ambiguous. Instead, we recommend that you consider the phrase, I just want to keep things clear, or the goal of just keeping things clear. This goes back to what I said on the last screen. Even though it may be more complex, a more complex estate plan that accomplishes goals can and should be clearly explained to you and your loved ones to keep expectations clear. That should be the primary consideration, not simplicity. What's another one that we see? Everyone in my family gets along fine. I've had people tell me I am confident no one in my family would sue. We all get along really well. That's great, and that's a really valuable thing to have if that is the case. However, we know that relationships change, and we know that these situations tend to bring out the worst in people, and that's a very unfortunate fact of life. Trusting that everyone will get along may make it to where your family never speaks to one another again because of an issue that was created after your death. Instead, consider, I want everyone in my family to get along after I'm gone. And the way to do this is through, we believe, comprehensive estate planning. That's the way to accomplish, that's the way to keep relationships intact and keep people moving through these situations. All right, so what are some ways to plan for relationships, specifically marriage? Our recommendation, and we see this as being a very popular estate planning tool in Colorado, is by using a revocable living trust. Real quickly, if you're not familiar with the relationship of a trust is a contract between the person who creates the trust. They go by different roles, but the most common one is the grantor. The person who's in charge of the trust, they are called the trustee, and the person who is the beneficiary of the trust, they are considered the beneficiary. When you use a revocable living trust, you can fill all three of these roles at the same time. The sentence that summarizes that underneath there says, you create a trust to hold property for your benefit that you are in charge of. Of course, you can create more complex trusts as well, such as irrevocable trusts, but those typically come up for complex estate planning needs, such as tax planning. What are the benefits to doing a trust? Well, first of all, a trust is a private document. You can keep your affairs more private through a trust than you can a will. A will is a public document. Anyone listed in a will is entitled to receive a full copy of the will, even if they're disinherited. A trust can also help avoid probate, and the big thing there is how long probate takes. A minimum time period for probate in Colorado is 6 months. The other thing to consider is the added cost of going through probate. And so a lot of times people want to avoid probate. If you put your property into a trust correctly, you can avoid the probate process here in Colorado. The last thing is that a trust allows for better planning for disability. Real quickly on this, consider that a will only goes into effect on your death, whereas a trust goes into effect immediately. And so for that reason, we consider a trust to be a will substitute. It can take the place of a will. So these are some benefits. Some other benefits that they might improve, and this comes up for your loved ones after you're gone, is that a trust can provide asset protection for your children from divorce, creditors, or lawsuit. And you do this by using an independent trustee called a directed trustee. They can also provide remarriage protection, and this is a way to make sure that you are providing an inheritance for your children, even if your spouse gets remarried. And then ultimately, trusts allow for better control of assets from beyond the grave to incentivize and protect things, etc. I do just want to briefly show for you on the slide here some advanced tax planning strategies that are available, such as advanced estate tax planning, portability planning if one spouse does not use all of their estate tax exemption, generation skipping transfer if you're skipping a generation going to grandchildren, and then certain tax elections that are available. These should all be covered by your attorney when you meet with them, specific to your situation. You may not have a taxable estate, and so this may not be applicable. Some other documents to consider. This goes into planning general durable power of attorney. Who is that? Is that your spouse? Is that your significant other? Is it your son, daughter? Is it some combination of those individuals? What's a healthcare power of attorney? Well, that's someone who makes healthcare decisions for you if you can't communicate your own wishes. A living will deals with end-of-life treatment. How many days would you want to go in a persistent vegetative state before withdrawing life-sustaining procedures? HIPAA authorization. Who has access to your medical records and files during your life and after your death? What if you need a guardianship or a conservator? This especially is applicable to minor children, but it might also be to you if you are in need of one. Who have you appointed to do that? And then what would you direct your loved ones to do with your last remains? How would you dispose of your last remains? These are just some other traditional estate planning tools that come up. Some things to consider. First of all, are you clear on the status of your marriage? Again, very few people, I think, would say that they are unclear on that, but it is a conversation to have. I had a conversation with the CPA about it. He said that they did have a child, they were living together, and they had been for the past 2 or 3 years. They had joint accounts and things of that nature. And he said, now we're not common law married, right? And I told him, I said, this is a conversation you want to have with your significant other, because I wouldn't know what to tell you. It's possible that if you were to die, your significant other would make a common law marriage claim. And so why not go ahead and have that conversation up front so that you know? Does your estate plan take care of your loved ones with remarriage protection, providing for your biological children and accommodating a blended family? If not, maybe you want to have a conversation about how to accomplish that. And then this goes back to the question I started things off with. Have you or someone you know gone through a relationship split recently? If so, have you reviewed your beneficiary designations, your property ownership, and who's serving in your plan as a helper? These are some big things that you may want to check on. Finally, where do we come into play? Well, we are more than happy to provide you with a no obligation meeting to meet with anyone regarding where they are at with their estate planning, where they want and need to be, and how to get there. And just up front, so you know, we do our fees on a fixed fee basis, so you do not have to worry about how long that takes. We don't do it hourly, we don't charge hourly. We do it on a fixed cost basis, and our focus throughout the whole process is your education and customization to fit your needs. The only investment we ask you to make up front is the time that it takes to come in and meet with us. So we're really doing our best to make sure that this is risk-free. We're happy to discuss if any questions have come up through this presentation. We're happy to discuss those with you. We encourage you to reach out to us, and we appreciate your time. Thank you so much again for joining me today. If you have questions, I'd be more than happy to try to take a look at those in the question answer feature of the Zoom meeting today. If you're watching this later, we encourage you to reach out to our offices. The phone number is there, our addresses, fax number is there, or visit our website to find out more on how to contact us. Otherwise, thanks again so much for your attention. My name is Tim Parks, and I'm here presenting on behalf of Davis Shulkin PC.